Welcome to the Real Estate Syndication Show. Whether you are a seasoned investor or building a new real estate business, this is the show for you. Whitney Sewell talks to top experts in the business. Our goal is to help you master real estate syndication. And now your host, Whitney Sewell.
This is your daily real estate syndication show. Today, our guest is Arina Shulga. Thanks for being on the show, Arina.
Thank you for inviting me.
Yeah, so I'm so excited to have Arina on the show. She's our first syndication attorney that's been on, and I've had so many people ask questions. And so she's a corporate and securities attorney. She's a founder of Ross and Shulga PLLC. She's active in the New York City startup community. And Arina, to get us started, would you just give us a little about your background? You know, how you got in to this field of being a syndication attorney, and just what that entails.
Okay, well, so let's start with my background. I've been a corporate and securities attorney for over 15 years. And real estate syndication is conducting a securities offering. So that's how I got involved in this space. I continuously advise clients on compliance with securities laws, whether they are a startup company or a growing company, or even, just different size companies, because the laws actually apply to issuers regardless of their size. So when somebody is pulling money together from investors, whether you call it a real estate syndication, whether you call it whatever else you want, a Series A round or anything else, it is a securities offering, and that's how I get involved.
Nice. So could you just tell us, why is a syndication considered a securities offering, and what is a securities offering? If somebody's hearing that for the first time, what does that mean?
Okay, so every time a company or an entity is raising capital, right, it's getting money from others, and in exchange is giving them maybe a promise to pay back, right? Maybe it's a security, maybe it's interest in the company. So the actual process of getting that money is a securities offering. So let's say you invest, or let's say you're a passive investor and you want to make money, right? You want to generate a return, make a profit. But you don't want to be involved in actual making of the process, profit, right? So you're going to entrust your money to somebody else, right, with an expectation that based on the efforts of that somebody else, you are going to make a profit on your money. This is called an investment contract. And that investment contract doesn't really matter what field or what area it is in. It is considered to be a security, right? And according to the Securities Act of 1933, every securities offering must be registered under Section 5 of the Securities Act, unless you find an exemption from registration. So when you say maybe a private placement, you actually mean an offering of securities that's conducted pursuant to an available exemption from registration. And that's what essentially private placement is. And most real estate syndications, they are private placements of securities, because you don't register anything with the Securities and Exchange Commission, right? You are following the rules pursuant to which you are exempt from that registration.
Nice. So, why don't we go into accredited investors versus non-accredited? If you could just briefly touch on that, and then we'll move on to why we need to know that.
Okay, so an accredited investor, and the definition is a lengthy one, so I'm just going to focus on the part of definition that involves individuals. So an accredited investor is someone who makes over $200,000 a year, has made that much in the previous 2 years, and has a reasonable expectation of making that same, at least that same amount this year, or 300,000 together with that person's spouse. Also, an accredited investor is an individual who has over $1 million in assets, but excluding the value of that person's primary residence, right? And so when we look at assets, we also look at liabilities and we deduct those. So that's kind of the 1 million that the SEC is looking for.
Okay, so are real estate syndications limited to only accredited investors, and if not, what are the conditions? What do we need to know?
Well, most private placements, including real estate syndications, are conducted involving only accredited investors. Most, but not all. There are ways to get non-accredited but sophisticated, right? Sophisticated investors to participate in an offering, but on a limited basis, right? So one of such rules that's actually commonly, or exemptions, let's say, that's commonly relied on in conducting private placements, including real estate syndications, is Rule 506B. 506B as in boy, that's pursuant to, or it's called Regulation D as in David. So that's one of the rules that forms part of Regulation D. So 506B allows the offering to be extended to up to 35 non-accredited investors, but they have to be sophisticated. That means that either alone or with an investor representative, they have to be capable of understanding the risks of that investment, and be able to really understand what that investment opportunity is about.
So 506B, 506C, could you just kind of tell us what the difference is, just so our listeners understand what that means?
Yeah, so I kind of already briefly talked about 506B. So those two rules, 506B and 506C, they are part of Regulation D. Regulation D is a safe harbor for a private placement exemption, okay? Section 4A2, that's your private placement exemption, and this rule kind of is a safe harbor for that private placement exemption. So 506B allows you to offer securities to an unlimited number of accredited investors, unlimited, and up to 35 non-accredited investors. The amount of the offering is unlimited, right? But if you, and also the rule generally doesn't require you to provide any disclosure information to the investors, so long as they're all accredited. However, if you decide to take money from at least one non-accredited investor, you need to provide such non-accredited investor, and then you should probably provide it to all investors, an offering memorandum that contains very specific disclosure that's mandated by the Securities and Exchange Commission. Like it's actually, they have a rule that specifies exactly what type of information you need to provide, which generally, definitely increases the costs of the offering, right? And requires additional time to prepare such offering memorandum or a PPM, a private placement memorandum. So you also file Form D with the SEC, Securities and Exchange Commission. And you also make notice filings in every state where the investors are from. Okay, Rule 506C. The main thing about 506B is that it does not allow you to conduct any general solicitation or advertising, right? So you can only reach out to your pre-existing, to persons with whom you've had pre-existing relationships. So what is a pre-existing relationship?
Thank you.
That's basically, enough, like it's not defined in the law, okay? But essentially, you know this person well enough to be able to understand that person's level of sophistication and financial situation. So does it mean a quick phone call? Probably not. Does it mean several meetings over a period of time? Yes, it does. Also, you can rely on perhaps your advisors, especially registered broker-dealers, maybe if you're conducting an offering through a broker-dealer, on their Rolodex, a list of their existing clients, because they already have that pre-existing relationship with the clients. Therefore, you can rely on that as well. So a lot has been written about what is a pre-existing relationship, right, or not. Like, for example, if you just get up at a meetup, get up in front of people and start talking about your real estate syndication opportunity, that is, I'm assuming that would be general solicitation and advertising, correct? And especially if at the end you say, and here's this great opportunity to invest. If you're interested in investment in this particular opportunity, come talk to me. That would, be general solicitation and advertising, and that does not establish a pre-existing relationship just because you happen to be in the same room, right, with people. So, but if you do go to maybe an angel meeting, it's an existing angel group, angel investors, right, where everybody knows one another and you know that they are all accredited. And when you talk there, the SEC has said that would not be a general solicitation advertising. Definitely emailing, like just sending a mass email to people, would be general solicitation and advertising, for sure. Also with online platforms, if you have a website just for your investment opportunity, that is a general solicitation and advertising, because it is accessible by everyone, right? But if you limit that certain portion of the website to a password protected area that can only be accessed by, through a password, right? And you do check such persons' credentials, maybe financial history, to be able to ascertain their accredited or not accredited status, right, before letting them there. Then this does, with time, even though it's not clear what amount of time should pass, but does let you kind of develop this pre-existing relationship, and then it allows you to then offer or make offers to such persons once they're inside that password protected website. Okay, so that's about pre-existing relationship and general solicitation and advertising. But what's good is that now we have Rule 506C, as in cat, that actually allows you to raise money from an unlimited number of accredited investors, and it's unlimited amount, right? And allows you to use general solicitation and advertising. Right, wonderful, right? So, but there is one catch, and that is you can only accept money from accredited investors. Not a single non-accredited, no matter how sophisticated that person is, right? Non-accredited investor can be accepted. Even one single instance will disqualify your entire offering. So the issuer, actually, it's no longer enough to take reasonable steps to, have a reasonable belief that the potential or prospective investor is an accredited investor. The issuer must take active steps, reasonable steps, to ascertain the status of that investor, right, before taking any money from that person. So it becomes it's all on the issuer, the burden is on the issuer to make sure that that person is an accredited investor. And that can be done in several ways. So the issuer actually has to, I don't know, maybe receive W-2s from that person and see that, yes, the person does make more than 200,000, and look at W-2s from previous years to make sure that that's the case. So that's possible, and obviously keep records of that. But then not all investors really comfortable disclosing their financials, to someone. So what people, or what the industry has been doing, right, is getting certification letters. You can actually disclose all this information to your CPA, your accountant, right, as an investor. And the CPA can prepare a letter for you, kind of saying that as of such and such date, this person is an accredited investor. These letters can be issued by a CPA in good standing, by an attorney in good standing, licensed, a registered broker-dealer, and I believe also by registered investment advisor. So there are actually platforms online, there are companies online that also offer this type of services, where you can submit your information and then they issue you a letter. And then using that letter, you can then kind of satisfy this requirement.
So to clarify just a little bit there, or just kind of tell you how myself and numerous syndicators are in the business, something they have on their website, so like if you reach out to contact me on the website, it asks, are you accredited, or are you non-accredited or sophisticated? And so if you're doing a 506B offering, is that sufficient to, as far as their accreditation status, as opposed to, doing the 50, if we're doing a 506C, I understand we have to go a little beyond that to confirm, their status, like you were talking about, correct?
Yes, exactly. So 506B, you need to have, the issuer needs to have a reasonable belief.
Okay.
And the issuer is not required to actually look at W-2s to make sure that this is true. So if the investor is lying, well, I mean, if the issuer kind of has a reason to believe that the investor is lying, then it's not a reasonable belief anymore, right?
Right.
But if there are no red flags, and the issuer, maybe there is an online questionnaire where the issuer needs to check boxes why exactly that, the investor needs to check boxes to say exactly why they're accredited. Maybe it's because of the assets, maybe it's because of the income. Then that's all, the reasonable belief is satisfied. But if you're doing a 506C and you want to generally solicit and advertise, then that's not enough at all. And you can offer the opportunity to everyone. Obviously, if it's on your website, you can't help but offer it to everyone, accredited or non-accredited. So it's only at the time of purchase, when it becomes absolutely necessary for you to take money only from accredited investors and know for a fact that they're accredited, and keep the records so that if there is ever any question or investigation, you have records to prove that these people were in fact accredited. So,
can you talk to the point a little bit about the pre-existing relationships, as far as documenting those? How should we document that to, if it was ever questioned about that relationship, are emails enough, or maybe, follow-up emails showing we've connected numerous times, or, phone logs, or notes from phone calls? What do we need?
Emails definitely help, because they show the whole timeline, that this is not just from yesterday, but from perhaps like several weeks or several months ago. Constant contact If possible, maintain a log of how often you've reached out to that person, and that you've had meetings, that, kind of document that you had the opportunity to get to know this person and that person's financial sophistication.
So, Arina, like when we are starting a syndication or we're starting to look at properties, when do we need to contact somebody like yourself, and what does that relationship look like?
Well, as soon as possible, because basically before you start even offering, right, this opportunity to others, obviously before you start taking any money from the investors, the attorney would prepare a private placement memorandum, even though I said that it's not required, right, by law, unless you're offering to those 35 non-accredited but sophisticated under 506B. It's recommended. And in the real estate industry, it's pretty much the norm that you would have a PPM that's describing your investment opportunity. But it takes time to prepare it, right? So definitely, as soon as you have kind of the investment strategy in place, get in touch with the real estate syndication lawyer or a securities lawyer, who can then put together a PPM for you, as well as and obviously you'll need to create an investment entity, the entity that's actually going to go ahead and make the purchase of the real estate. And you will need to have either a subscription agreement, right, that's going to evidence the fact that you took the money in exchange for interests in that purchasing entity.
So, can you, I guess, tell us, does it matter what state you're in versus what, where we're buying the property or where investors are, or intrastate offerings versus interstate? How does that work?
Well, typically you would have your purchasing entity perhaps be a Delaware entity. It's very common, to use Delaware LLC for that. And then it doesn't have to be that the property that you're purchasing is in the same state. There is no such requirement, especially now. You can use or rely on, there is another exemption from registration that's for intrastate offerings, which I haven't mentioned because it's not used as commonly as regulation deem private placements, but basically it's limited to one state, like investors from one state. So if, for example, you had your property in one state, let's say New York, and you had all your investors be from one state, then it's okay if your purchasing entity were like a Delaware LLC. But as long as it was doing business in New York, then it would all be fine, and you could rely on that Rule 147A. But that's it's not like commonly used as an exemption, and I think reliance on 506B or 506C is much more common. And for that, it doesn't really matter where the property is located.
So, I've heard different people talk about and ask about what can I legally say on the internet. And I know we talked about, 506B versus C and what, if we can advertise or not. But if I'm putting out just about my company, this is what we do, I mean, there's no issues there, but it's when I actually say I have a property, this is our projected returns, that's when I'm advertising that property, correct? It's not so much if I'm just saying this is our business, this is what we do, purchasing real estate. Can you decipher what's too far, just to blast out on the internet?
Yes. So yeah, definitely that would be advertising, of the investment opportunity. So the general rule is that you have to provide, like, all the material information that you provide has to be true, and there shouldn't be any omissions or misstatements. right? So that's called a 10b5 liability. So whatever you are responsible for the statements you make, and they have to be true in all material respects, and that means they cannot omit or leave out any material information as well, right? So you always have to present the full picture. So obviously, when you're talking about projected returns, you have to say that they're such, and that things can happen that may render these returns be inaccurate, right? So a disclaimer is definitely a good idea to have on your website, right? And especially when you're talking about projected returns, I mean, so many things can happen. Oh God, I remember drafting these risk factor sections for the PPM, for real estate PPMs. Oh, they go on for pages and pages, right? So you can't really promise a return. You can say that, and obviously, and that the past performance does not, mean or guarantee a future outcome.
Right.
So all this has to be made very, very clear to the investors. So just putting on your website just this amazing projected returns and that's it is kind of misleading, because an investor, if the investor is not sophisticated, I mean, I hope they are, but definitely can think, oh, this is it. These guys are pretty much guaranteeing that. But that's not the whole picture, right? You also have to mention, but wait a second, so many things can go wrong. And we may not ever be able to achieve these results. And this is why. So even in the marketing materials, so the brochures have to be very careful. And yes, you can talk about projected returns, but you also have to talk about the risks that associated with the investment, and then refer the investors to the full PPM that kind of provides a full picture of all the information related to the investment.
Great. So yeah, I think, most of the people that I talk to, it's like, we don't want to put anything on social media that shouldn't be there or get us in trouble, obviously, and so we just want to be careful. We want people to know, or potential investors to know, what we're doing. But we want to be careful that we're not violating any kind of law or regulation,
Yes, absolutely. And it's also important to make sure that whatever you write on social media or the web page is not different from what's in your PPM. You need to control the amount of information that's out there, right, about your offering. So in the PPM, the whole idea of why you would have a private placement memorandum is kind of telling the investors, look, this is the information that we are preparing. We are the sponsors of this deal, right? And this is the information you can rely on when making your investment decision. So whatever somebody else says is, it's up to you to listen, but whatever is in the PPM is the information that we're providing to you and we're responsible for. So, and that's, and then you make sure that it's all correct. There are no material misstatements or omissions in that information, and that you're comfortable with it, right? Whatever is in the PPM. So it's in your interest to kind of use the same information when placing whatever, like an ad or whatever you decide to do on social media or the website. It needs to be the same information.
Right. No, that's great. And before we have to go, are there any common mistakes maybe investors make that you see, or common questions, that maybe you could answer, or, especially mistakes that, that are common that we need to know about?
I would say kind of presenting the full picture to the attorney, and not hiding any facts which you may think that are, that the investor should not know about. That's definitely one thing that always worries me, because we as attorneys, we have limited opportunity to do due diligence, right? So we have to a certain extent, rely on the information that the sponsors are giving us. So that information has to be complete. So even if it's something negative, it's better to get it out there and explain than be silent about it. That's number one, I would say. Secondly, it's important to remember that the PPM is not your marketing brochure. No, I've seen it countless times when I get this investment strategy, section from the sponsors, and it's so rosy. It's all like amazing. It sounds like a marketing brochure. No, a PPM is a disclosure document. So we disclose the investment opportunity, we describe it, we compare it to other investment opportunities or to the market, right? We look at whatever, let's say it's in a certain given state, in a certain given geographic location. So let's talk about the location. Let's talk about other businesses around that. Let's talk about unemployment rates in that industry, in that area, right? Let's describe that. But let's not present the rosy pictures. Let the numbers talk for themselves. And also when you're talking, when you're citing any information, you need to provide a source for it, right? Because I would check. I was like, if you tell me that the unemployment rate in South Carolina was such and such, I will go there. I will check that source to make sure that that's actually true, because that makes part of the overall information that the investor will later use to make their investment decision. So it all has to be accurate.
That's some great advice, Arina. And is there anything else that I haven't asked you that maybe, that you should tell us that, we need to know before we have to go?
Well, if possible, take money from accredited investors only. It's just, even though, yes, there are ways to get non-accredited investors in. Yes, there are. But it increases the cost, legal cost of conducting the syndication. It also increases the complexity and definitely increases the risk that these individuals will not actually understand the true risks involved with any given offering. Nice.
Arina, you've been a great guest. I really appreciate your time and you being on the show. Would you tell the listeners how they can learn more about you and your company?
Sure. You can go to our website. So it's www.rsglobal.law, L-A-W. So R as in Ross, S as in Shulga, law, L-A-W, rsglobal.law. And they can always email me. My email is on the website, and just in case, it's my first name, Arina, A-R-I-N-A, at rsglobal.law.
Great. Thank you so much, Arina. And I know myself, I've learned a lot from you just today, and I know the listeners have too. And I hope the listeners will go to the Facebook page and will join our Facebook group so they can interact with guests like Arina, and we can all improve our businesses and make sure we're doing it legally. So we will talk to each of you tomorrow. And thank you again, Arina.
Okay. Thank you very much. Thank you. Bye.
I want to tell you about an upcoming real estate investing conference hosted by my good friend, Joe Fairless. Every February, Joe brings his best ever conference to Denver, which brings together the top high-level experienced real estate speakers and sponsors that has proven to be the best ever networking, content, and strategies to help grow your portfolio. The earlier you buy, the more you save. Ticket prices increase weekly, so you want to buy today. I attended in 2018, and I can guarantee you do not want to miss this conference. February 22nd and 23rd, 2019 in Denver. Go to besteverconference.com to reserve your seat today. That's besteverconference.com and use hashtag Whitney to save 10%. That's hashtag Whitney.
Thank you for listening to the Real Estate Syndication Show, brought to you by Life Bridge Capital. Life Bridge Capital works with investors nationwide to invest in real estate, while also donating 50% of its profits to assist parents who are committing to adoption. Life Bridge Capital, making a difference, one investor and one child at a time. Connect online at www.lifebridgecapital.com for free material and videos to further your success.